Rhode Island packs a lot of tenant protection into the smallest state in the country, and its lease termination laws are no exception. The governing law is found in Rhode Island General Laws, Chapter 34-18, the Residential Landlord and Tenant Act, and landlords who don't follow the procedures precisely can find their eviction cases thrown out of court. Let's start with no-cause termination. For month-to-month tenancies, Rhode Island requires the landlord to provide at least 30 days written notice before terminating. The notice must expire at the end of a monthly rental period. For tenants, the same 30-day notice requirement applies if they want to end a month-to-month tenancy. For fixed-term leases, the lease expires at the end of the agreed term. Rhode Island does not require additional notice at the end of a fixed term unless the lease specifies otherwise. If the tenant remains in possession after the term expires and the landlord accepts rent, the tenancy converts to a month-to-month arrangement under the same terms and conditions. For week-to-week tenancies, Rhode Island requires 10 days' notice from either party, slightly longer than the 7 days most states require for weekly tenancies. Now let's cover termination for cause. For non-payment of rent, Rhode Island has a specific process that landlords must follow carefully. Under Section 34-18-35, the landlord must provide a written notice demanding payment. The tenant then has 15 days to pay the rent owed. If the tenant pays the full amount within 15 days, the notice is void and the tenancy continues. If the tenant doesn't pay, the landlord can proceed with filing for eviction in district court. Rhode Island's 15-day non-payment window is longer than many states and reflects the state's emphasis on giving tenants adequate time to address financial difficulties before losing their housing. Landlords need to be patient with this timeline and resist the urge to file early. Doing so will result in dismissal. Here's an important nuance about Rhode Island's non-payment process. The state has a right of redemption that extends even into the court proceedings. Even after the landlord files for eviction, the tenant can pay the full amount owed, including court costs and any late fees, and stop the eviction at any point before the court enters a final judgment. This right of redemption makes Rhode Island more forgiving to tenants than states where the right to cure expires once the notice period ends. For lease violations other than non-payment, Rhode Island uses a 20-day notice to cure framework. Under Section 34-18-36, the landlord must provide written notice specifying the violation and stating that the rental agreement will terminate if the breach is not remedied within 20 days. If the tenant corrects the violation within 20 days, the notice is void. If the tenant doesn't cure, the landlord can proceed with eviction. For repeated violations of the same type within a 6-month period, Rhode Island allows the landlord to terminate with 14 days' notice without offering another opportunity to cure. This prevents the cycle of violation, cure, and repeated violation that can frustrate landlords in more tenant-protective states. For serious violations, including criminal activity on the premises, drug-related offenses, and conduct that poses an immediate threat to the health or safety of other residents, Rhode Island provides an expedited process. The landlord can seek an emergency order from the court, and the hearing can be scheduled on a shortened timeline. Courts in Rhode Island take drug activity and violent crime on rental premises seriously and will act quickly when the evidence supports it. Rhode Island also has a specific provision addressing situations where the tenant creates a clear and present danger to other tenants or to the property. In these cases, the landlord can file for immediate eviction, and the court has authority to issue temporary orders removing the tenant pending a full hearing. One area where Rhode Island has been increasingly active is the protection of tenants in foreclosure situations. When a rental property is foreclosed, Rhode Island law provides tenants with certain protections regarding notice and the continuation of their tenancy. The new owner must honor existing leases and provide proper notice before terminating, which is important for landlords who acquire properties through foreclosure. On the tenant side, Rhode Island provides several grounds for early termination. If the landlord fails to maintain the property in habitable condition, As we covered in our Rhode Island habitability video, the tenant can provide written notice and allow the landlord a reasonable time to make repairs. If the landlord doesn't act within 20 days for non-emergency issues, the tenant can pursue remedies including lease termination. Tenants who are victims of domestic violence, sexual assault, or stalking can terminate their lease early under Rhode Island law. The tenant must provide written notice along with documentation such as a protective order, police report, or a written statement from a qualified professional. The notice period is 30 days, and the landlord cannot charge early termination fees or penalize the tenant for breaking the lease. Active duty military members are covered by the Federal Service Members Civil Relief Act and can terminate with 30 days' notice following deployment or permanent change of station orders. Rhode Island also provides early termination rights for tenants who are elderly or disabled and need to relocate to a care facility. The tenant must provide adequate notice and documentation supporting the need for relocation. Rhode Island strictly prohibits self-help evictions. Under Section 34(1834), landlords cannot change locks, shut off utilities, remove doors or windows, remove the tenant's belongings, or take any action to force a tenant out without going through the court process. The penalties for self-help eviction in Rhode Island are serious. The tenant can recover up to 3 months' rent or 3 times actual damages, whichever is greater, plus attorney's fees. These penalties make self-help not only illegal but extremely costly. The eviction process in Rhode Island goes through the district court. The landlord files a complaint, and the court issues a summons to the tenant. The hearing is typically scheduled within a few weeks of filing. Rhode Island courts are known for carefully examining the landlord's compliance with notice requirements, and any defect in the notice, wrong dates, insufficient detail, improper delivery, can result in dismissal. If the court rules in the landlord's favor, a judgment for possession is entered. The tenant then has a period to vacate, typically 5 days, before the landlord can request a writ of execution. The sheriff then carries out the physical eviction. The overall timeline from filing to removal can range from 4 to 8 weeks, depending on whether the case is contested and how busy the court is. Rhode Island also has specific rules about how abandoned property must be handled after an eviction or voluntary move-out. The landlord must store the tenant's belongings for a reasonable period and provide notice before disposing of them. Failure to follow these procedures can result in liability for the value of the disposed property. Rhode Island requires landlords to return the security deposit within 20 days of the tenant vacating the premises. The landlord must provide an itemized list of deductions if any portion of the deposit is withheld. If the landlord fails to return the deposit or provide the itemization within 20 days, they may be liable for double the amount wrongfully withheld. For the complete guide to Rhode Island lease termination laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our series.